please introduce yourself and your teacher coach?
Good afternoon. We are Reno High School's Unit 5. I'm Michaela Jolder, and I will be attending the University of Nevada.
I'm Kaylee Conrad. I'll be attending Northwestern Preparatory School.
I'm Lauren Parney, and I will be attending the University of Oregon.
And I'm Ben Nebesky, and I'll be attending the University of Nevada. Our unit coach is Mr. Scott Daniel, and our teacher is Mr. Richard Clark.
Thank you. Would you continue to speak up so we can hear you? I have hearing aids, and this unit over there I can hear very well. All right, this is Unit 5, Question 3 we're going to do today. And I'll read the question so there's no misunderstanding. If I were king, I would not allow people to go about burning the American flag. However, we have a First Amendment which says that the right of free speech shall not be abridged. Burning the flag is a form of expression. Speech doesn't just mean written words or oral words. Burning a flag is a symbol that expresses an idea. Do you agree or disagree with Justice Scalia's opinion? Why or why not? And how has the meaning of free speech, as defined by the courts, changed over time? And furthermore, should the government ban websites that advocate hate speech towards ethnic, racial, or religious groups? And why or why not? And lastly, what, if any, are the restrictions courts have placed on freedom of expression? And which of these restrictions do you support or oppose? So please.
In his concurrence in Whitney v. California, Justice Louis Brandeis stated, "If there be time to expose through discussion the falsehood and fallacies to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence." We agree, the First Amendment allows for discussions on difficult, even uncomfortable topics, but it is one of our most important protections for the progression of society. In the decision for Texas v. Johnson, the court stated, "If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable." We agree with Justice Scalia when he advocated for Johnson's right to burn the flag, even though this is something we may personally not ever engage in.
The court's definition of free speech has changed over time because when the framers wrote the Constitution, speech was not as extensive as it is today. The meaning of speech has evolved into not only literal words, but also forms of expression, such as writings, paintings, appearances, or actions. One of the first cases about symbolic speech was Tinker v. Des Moines in 1969, where the court established that students wearing armbands to protest the Vietnam War was a form of symbolic speech. Because it did not create a material disruption, the speech was protected.
In the 1971 case of Cohen v. California, Cohen wore a shirt to court with the phrase "fuck the draft" and was subsequently charged with offensive conduct. However, the court ruled that his shirt was protected because it conveyed a political message. 3 years later, in the case of Smith v. Guggen, Smith was convicted for wearing an American flag patch on the bottom of his jeans. The court ruled that the flag desecration laws that prohibit contemptuous treatment of the flag were overly broad, but the legislature has control over the treatment of the flag since it was considered national property. This case was challenged by Texas v. Johnson in 1989, when the court changed its perspective of the flag and what people do with it as a freedom of expression.
Hate speech is generally protected for the benefit of society, so we can have conversations and progress as a whole. However, because of technology, this First Amendment protection has become more complex. The government has taken some technology access into their own hands, such as in the 2003 case, United States v. American Library Association, where Congress refused to fund library internet access if it did not uphold the Children's Internet Protection Act, which restricts access to websites such as pornography. Websites advocating hate speech toward particular groups are protected, just like hate groups are protected in reality. Websites can be seen as more dangerous because hate groups can meet, discuss, post, and share everything and anything they want online. However, if there is no imminent danger, the government cannot shut the website down. Only a true threat online, like cyberbullying, has been recognized and received legislation restricting it in all 50 states.
In the 1988 case of Hazelwood v. Kuhlmeyer, it was ruled that schools may limit student speech that was deemed unfit in school publications. We disagree with this restriction because it limits the editors of school publications such as newspaper and yearbook's voice. Recently, in Reno, Nevada, the Washoe County School District proposed to put a limitation on yearbook publishers' voice by not allowing the addition of school sport clubs to be published. This new limitation was seen as a violation of Nevada's new state Senate Bill 420, which makes it more difficult to limit student speech by advocating for full protection of student publications, similar to protections for newspapers.
Limitations on the content of speech within schools should be few so that new minds can discuss difficult and complex topics and learn the importance of their First Amendment rights. As noted in Tinker, students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Schools must allow for students to continue to grow so that their minds be ready to enter into the marketplace of ideas. Thank you.
Thank you. Please share your papers over. We have some questions for you. And I'm going to start off with the internet. Facebook has announced that it intends to filter or limit some types of communications. Is there an intention to take this action subverting users' First Amendment rights?
Because Facebook is a private company, they can limit some of their access and what people post. I would argue that by taking away this right, it's becoming, for the people, it is becoming less likely to be let me rephrase that. It is becoming a threat to some of the First Amendment rights.
Building off my colleague, Facebook has limited speech in the past for obscenity. Seen when someone posted a picture that was actually featured in the Pulitzer Prize winning category, but it was on Facebook and it featured a naked girl, and Facebook actually took it down. So they have limited speech in the past. However, they are, like my colleague said, a private company, so they can do it.
Additionally, because Facebook is such a large organization now with so many members around the world, it can be seen as one of the largest public forums that we have. So limiting that speech can be dangerous because it limits the ability to openly discuss topics with a multitude of ideas and opinions.
Thank you. Erin?
Should government require controversial speakers to pay for extra security at events where they're scheduled to speak?
No, they shouldn't have to pay for extra protections. Maybe security in that sense, depends what you mean by protections, but as far as the speech goes, no, they shouldn't have to. They should openly be allowed to express those ideas, because if they don't, they will go underground and become a more dangerous threat.
In disagreement with my colleague, speakers should have to pay for the security that they are given during a speech, because the speaker, under the Constitution, their speech is protected, but they themselves are not protected, because when they are speaking in a public university, the security risk could potentially limit the ideas entering the marketplace of ideas.
But isn't the prospect of putting in such a huge dollar amount as a way to prohibit somebody from exercising the right of speech because they couldn't possibly afford to pay for it?
I would agree with that. In Citizens United, it was ruled that money and contributions to campaigns is seen as a form of free speech. However, I disagree with that opinion because it gives the notion that some individuals have more free speech than others because of the money they possess. So if a speaker does not have the opportunity to pay for extra protection, their speech will be limited in that sense.
You know, you raised, when you were speaking about the Fuck the Draft case, it raised an interesting question. If a person were to wear a t-shirt to court, in my courtroom, that said, "Fuck the courts," and I told him he had to turn the shirt inside out if he was going to be in my courtroom, or even worse, decided to hold him in contempt, would I be violating his First Amendment right? What's your thought?
Yes, you would be violating his First Amendment rights, because that is political speech, and it is the highest or the most protected speech that the Constitution allows.
Well, there is seen almost as a dress code though in court. So by having him requesting that he does turn it inside out, you're just asking that he does apply to the dress codes. As in schools, there are dress codes that many schools do put in place, including public schools, not just private. So it's just so that overall there's not a disturbance or a distraction in a sense that since these people are being required to be there.
You mentioned the limits of free speech in public school settings. Do you think it would be appropriate if a private school enacted more restrictive limitations?
Yes, it is appropriate because they are a private school, so you are agreeing to their, I want to say terms and conditions, even though they're not technology, but you are accepting that when you go to that private school because they are privately funded and they have that restriction on you. Just like in our town in Reno, there's a school, Bishop Manogue High School, and they have extremely strict policies on what you can wear, what color socks you have on, and so on.
However, arguing against the idea of just having more restrictions in schools despite them being private or public. Students do need to express their ideas so that they can be understood and learn what is happening. So I believe there should be less legislation to keep private schools from enacting more restrictions onto.
Building on my colleague, private and public schools serve the same function. They're there to give an education to the youth of the United States, and if they're not serving that same function and allowing students to express themselves or use their freedom of speech to convey messages and discuss with each other and disseminate ideas, then we would be in a very dangerous place.
Along those same lines, there are universities now, both public and private, that have come up with lists of words. You know, they have trigger words and things that are not allowed to be used on campus. Does that, both public and private universities have that? And you said before about private schools, and they're allowed, based on their agreement, you're going to live by their rules. But what about those trigger words, use or non-use of those trigger words in a university setting that's a public university? Would that be a violation of the First Amendment?
I don't know that it would necessarily be a violation of the First Amendment, because the original intent of trigger warnings was to warn typically people with post-traumatic stress disorder of something that could possibly cause harm to them. However, now it has become more mainstream, and so a lot of people use trigger warnings as a way to avoid discussing uncomfortable topics, and a lot of colleges have limited their curriculum to avoid those uncomfortable topics, which takes those out of the marketplace of ideas, and rather than educating, we're avoiding those issues.
Building off my
Thank
comment.
you.